Hello, dear friends, my lovely audience. Welcome to the show, Jack Chow on the East West Show with GNE TV. Today, we're sneaking in to take this opportunity to learn something, to understand the U.S. laws, right? We're living in a law country. We call a law country because we can, everywhere we see, there is a law. There's a law for everything. There is a law for everything you do, right? We're using the case of Mr. Zhou LiBo's of China, famous, well-known, comedian, who was lately, previously involved in the case, right? And was finally set free with a little punishment for only cell phone call while driving for $150. And lots of people didn't understand. So we would like to use this opportunity to grab the case to indicate to you this is the law. What is the U.S. law? This is U.S. law. With me today in answering all the questions, in discussing about the case is my dear friend, my dear brother, Tom Yu, defense attorney, former LASD detective. Sir, welcome to the show.
Thank you, Jack. Good morning.
Very good morning to you. So, what do you know roughly about the case? We all know this case second-handedly, but as attorney, you might take a different perspective, please.
Sure. I mean, there's two lenses that a defense attorney would focus on in a criminal case. One is how the evidence got there, and the second portion is what the evidence is. For me, I don't even look at what the evidence is until I see how the evidence got there. So in this case, you have a routine traffic stop by an officer who sees a motorist driving with a cell phone. I've stopped thousands of people for various traffic violations. The officer goes up to the car. At some point, he pulls the motorist out of the car. That's okay to do. There's a case law called Pennsylvania versus Mims. It's a U.S. Supreme Court case that says that an officer with no reason can pull you out of the car.
All right.
Because the police officer's job in the eyes of the Supreme Court is inherently dangerous. So the cop can, just because he feels like, pull the person out of the car.
They can pull you out of your car.
Absolutely.
At any given moment.
Any given moment.
If they feel necessary.
In fact, not only the driver, but everybody. There's another case named from U.S. Supreme Court, a 2007 case, Brennan versus California, that says, stands for a proposition that if a police officer stops a car, everybody in the car is detained. No one's free to leave. So not only do you have to comply with the officer, you have to come out of the car. Now the issue becomes, can you search the car? See, I can pull you out of the car, but I can't search your car, or I cannot pat you down unless I have some other more additional reasons. Okay.
All right.
So, and I like to examine a case from a police officer's point of view because my experience as an officer.
Yeah.
Cop pulls a motorist out the car, says, get out the car. No problem. Passengers in the car, passenger come out of the car.
All right.
Okay. At that point in time, the cop can call for backup, issue him a ticket, or perhaps look at the person and whether maybe there's a drinking problem, maybe he's on some drugs. So you examine the case a little bit and you assess the motorist. Now, absent any other reason that an officer can articulate, person's got to go. The traffic stop is done. In other words, you can't go back and search the trunk. You can't search the person. You have to come up with some more reasons.
I see.
If it's 3 a.m, the person's under influence of some drugs, and you can see by the eyes, pupil dilation, he's sweating on a winter night. Well, that gives you more of a reason to investigate it. Maybe
to further doubt more.
Absolutely. But without any further specific and articulable facts by the officer, that traffic stop is done. Now, in this case, the officer stops the comedian, and they, at some point, go into the trunk. That's not allowed.
The reason for the officer to stop him was that he was caught making a cell phone calls while driving. The argument was, in the very beginning though, there was no call being made because the phone record doesn't even show at that specific amount of time calls coming in or call going out.
No.
And then the other side, the A side, say, hey, well, I'm playing with cell phones, but also distresses your driving or something like that. And there was the part they are arguing about back and forth, but not that part as the major issue. The major issue is that the officer went to look into the trunk.
Well, I mean, we have this thing, a doctrine called fruit of the poisonous tree. So if the beginning of the traffic stop is poisonous, which means the reason is invalid, then everything flowing from the traffic stop is also invalid. So, but to your point, Jack, I don't need to actually make a call. I don't even need to send a message. The moment I look at the phone, that's distracted driving. And the officer doesn't have to be absolutely sure. The officer only have to be probable. The legal reason, the legal standard is probable cause, not beyond all doubt.
All right.
So if the officer sees a person on a phone, that's probable cause to pull the person over. Now, the issue I have in this case is how did the officer get to the trunk? Right. So in other words, if I pull over a motorist at 3 in the morning and the person's drunk, he can't drive home. I'm arresting the motorist. Who's going to drive that car home? No one. So I have to impound the car. What do I do when I impound the car? I have to inventory the car, including the trunk. If I can go in the trunk not to search it, but to inventory it, that's an exception under the Fourth Amendment. Everything under the Fourth Amendment of our Constitution says that if you don't have a warrant, the search is presumed to be unreasonable, unconstitutional. So the officer and the government have to come up with an exception.
If you did impound the car, though, do you still can you still search the trunk?
Yes.
You can.
You're not. The word search in the Fourth Amendment has a very specific meaning. I still teach police officers, and when I teach police officers, I always teach them to say you're searching, but it's not a search. You have to have a warrant or an exception to the warrant if you're conducting a search.
Either a warrant or an exception.
To the warrant.
Where do the exceptions stand?
In inventory. Inventory the car, it's an exception. Because you have to go in the trunk and account for all the items. You have to say, hey, do you have expensive jewelry? Do you have cash in the trunk? Do you have like expensive pen in the trunk? A nice tie. Because if you do, I have to write it in my incident log. That
I see.
I searched it.
Now, at that point, it is legal for you to open the trunk.
To inventory it, yes.
To inventory the trunk.
Yes.
You're not searching, you're to inventory the trunk.
And this is where words gets tricky. You're searching, but you're inventorying for personal items.
All right.
Well,
in this comedian's case, though, if the officer said that I want to impound your car, right, for inventory, and then I need to check what you have here, so your personal items. What do you have? He said, I have a Rolex watch. Let's see the watch. Let's see in the trunk. Where is it? Open the trunk and see the watch, right? Yeah. And then log it, on and on and on and on. So that is not a search.
Well, number one, if someone has a license and they're not drunk, they're not going to be arrested, there's no reason to inventory and impound the car. How I would have done the traffic stop if I was a police officer is if the comedian was under influence, I would be able to detect maybe his pulse is really beating fast. A normal person's pulse is between 60 to 90. Person under influence of a stimulant can go up to 150. So you can take his pulse. You can see his pupil dilation. You can see if he's sweating profusely on a cold night. Maybe he's fidgeting around. There's several signs and symptoms very particular to someone that's under influence of cocaine.
To give you a handle to go on to further search, to further discovery, right?
Right. Well, it will give the case a life. But to get consent on a person that doesn't speak English, that's invalid. Consent has to be knowingly, voluntarily, and if the person doesn't know what they're consenting to, the consent is no good.
I see, I see. All right, my dear friend, today with me is my good friend Tom Yu. Mr. Tom Yu is a former detective of LASD. In other words, he was a cop, and he is now a defense attorney. And in my eye, he's everything in the criminal field. So we're talking about the Zhou LiBo, the comedian case. We want to learn something from it about U.S. laws, right? And the public opinion is one thing, but the laws are laws. The laws are still there, black and white, written that way. It is that to be interpreted that way. So stay with us. We'll be right back, please. Hello, dear friends, my lovely audience, and my dear fellow Angelinos. Welcome back to the show. Jack Chow with the East West Show with my friend, Mr. Tom Yu. Tom had been a LASD detective for many years, a successful, well-loved detective, a veteran I call, and an attorney right now currently for defense attorney. So we are taking and dissect a case which is the Zhou LiBo's New York case, trying to understand the U.S. laws, why he is innocent, why he is not guilty. Well, when the law says it. So Tom is giving us all his legal advices, legal explanations, and also either from a detective point of view, from police officer point of view, and also from court proceeding point of views. In between, before we reach court proceeding, we still focus on the site, right? At the site, though, it was more complicated than you can think of, because you're not talking about a direct conversation that I'm impounding your car, which is immediately understood by the driver, by the motorist, right? So the motorist, namely Zhou LiBo, the guy, the comedian, does not speak the language. Right. So how do you continue? Well, even if you wanted to impound the car?
Well, first off, the officer at that time, the moment the officer knows or should have known that there's a language barrier, there's translation services available to law enforcement. In New York, there are probably thousands of Chinese-speaking officers working the streets. I personally have worked with NYPD when I was a detective. I work with New York State Police, and there's hundreds of Chinese-speaking officers. So that should have been a first cue to get on the microphone, on the dispatch. And say,
I need an interpreter.
Absolutely. If that's not available, there's a violation. Remember, the officer doesn't have to cite someone. Citation is discretionary. So
you can just let him go.
You can let him go, absolutely. And I have let hundreds of motorists go. If I know the person seems to have their license and insurance and I see it, you don't have to cite someone. Now, the officer is trying to do his job because the officer has some reason to believe that maybe this person is violating some laws. There is a street cop sense. I can't explain it. It's in your sixth sense. Something is not right in this traffic stop. So the cop goes, well, can I search the truck?
In other words, there might be something that made the officer feel it was necessary to stop him and to continue search. Am I right?
Right. I mean, we're talking about after the traffic stop, during the conversation, the cop, I believe, felt the sixth sense that necessitated a further justification to go in the trunk. And remember, a cop doesn't search every car he stops.
Yeah.
So there's something that happened. Now, my analysis is how you got there. So how he got there was faulty. Now, what he got at the end was great. He got some drugs and a gun. But how you got there the key to the to the
So
search.
the best thing for the officer to do at that very moment was that as soon as he discovered that this person wasn't able to communicate in English, versus the fact that he felt it necessary to keep on going searching, right? So he will have to call for help, for backup.
Well, I tell you what, this is what I would have done. Okay. Let's say that Mr. Comedian was under influence of a substance, and I can see it. I can see it in his eyes. I can see it in the way he reacts to my questions. And I don't need him to speak English. The symptoms are universal, global. It's human reaction.
Okay.
So he's manifesting these symptoms. What I would have done is place him under arrest for being under the influence of a controlled substance. In California, it's a violation of 11550A of the Health and Safety Code. In New York, there'll be a different section.
All right.
What I would have done as an officer is put him under arrest and impound his car. Now, I get to inventory the trunk.
I see.
See, there's a lot of ways to get to criminals, and if the cop
You have
doesn't
the
know,
living evidence, you have the trunk evidence, right? Okay.
right. So the moment you place him under arrest, now you can inventory the trunk. Now you can't search the trunk just because you arrest someone. It's very different. That's what we call a search incident to arrest. And there's a case in 2009 called Arizona versus Gant. And that case, the U.S. Supreme Court says you can never, by the mere fact that you arrest somebody, automatically go to the trunk. But there's other exceptions like inventory. You're not going to leave a car out on the street. You're going to have to put it in the tow yard. Well, then you got to inventory the car, don't you?
And then you do your inventory list.
Absolutely. That would be
Right.
the smart way.
And then you log in everything. So then you can forcefully open it.
You can forcefully open it.
You can forcefully open it. You see a gun, which is loaded.
Right.
And you see a bag of cocaine.
Great.
Right? Those are strong evidences.
Sure.
Right? So, all right. And then you mentioned about court proceeding. From then on, it went to court proceeding several times, right? Several rounds. So what do you say from this case about this court proceeding?
So typically when a defendant gets arrested for a felony in this state, there's two ways you can do it. There's under the state law, you can get it by a complaint. So the detective takes the case in the morning. John Doe got arrested the night before. They have 48 hours, court hours, to bring this person into.
What is court hours?
Court hour means if you get arrested on a Friday, you get arraigned on Tuesday.
I see.
Meanwhile, the person can bail out. The person can get a bail bond agent, an insurance company to say, well, this person is not a risk to the public. There's no flight risk. There's not a danger to the public, and he can come out until his arraignment. So if the person bails out, the arraignment is typically 21 days. Okay. If the person doesn't get bonded out, then it cannot be more than 48 hours, court hours. So if you get arrested on a Tuesday, you go to court if you get arrested on a Friday, you go to court on Tuesday. When you go to court, you see a judge.
So Monday will be for 48 hours, right?
48 court hours.
Court hours.
Yeah.
So if you got arrested Monday, though, you're talking about Thursday.
Wednesday.
Wednesday, okay.
But if Tuesday is a holiday, and it's the next day.
I see, okay.
So when the detective takes the case to the prosecutor files a complaint. The complaint sets forth all the necessary information of the crime and the person.
Complaint or charges?
The charge is inside the complaint.
I see.
Okay. The second way to do it is by the grand jury. That's done at 1% of the case. I've done probably three grand jury cases as a detective. And they're all for multiple defendants, big conspiracy, wiretap, and murder cases. Usually, in most 99.9% of the case, Jack, it's all by complaint. You go to court, and the defendant retains a defense attorney, and we go in, we plead him not guilty. And the judge sets a date for a preliminary hearing date. A preliminary hearing is where the defendant goes before the judge with representing by the attorney and the prosecutor. The prosecutor brings down some evidence to show whether or not there's enough to go to trial. If there's enough to go to trial, then the DA's office, the prosecutor gets another charging sheet called the information. That's got to be done 60 days after the preliminary hearing. And then the person gets arraigned again in jury trial. In this case, in New York, also in California, the attorney filed a motion to suppress. It's called, in California, it's called a 1538 motion. I've done probably 100 of those. A 1538 is where the defendant goes before the judge and challenges the actual arrest. That there's not a legal reason to stop and to arrest and seize the defendant. There's two ways to do it, with warrant or without a warrant. Here we're talking about without a warrant because the cop didn't have a warrant. It's through a traffic stop.
All right, very good, very good. So in this case, in court though, the prosecution brought up the evidence, which is a gun, a loaded gun, and which is a bag of cocaine. So those were found in his trunk. So by then he was not concluded in the first trial, and the second whatever time goes on and on and on. The guy keeps changing lawyers, changing defense lawyers until he got this last one, which was successful. So in this whole process, what could be the area that a defense attorney, I do this for my audience to learn a message that it is important that you get a right defense attorney.
Yeah, absolutely.
Who knows what he's talking about.
Yeah.
Right. In Zhou LiBo's case though, several of his previous attorneys either made mistakes or they had other ill-minded purpose whatsoever, though, got him failed. And even the court date got to be postponed, and it was not clear. Guy was kind of abandoning. It was not doing this until the last moment, the very last moment.
Yeah.
So I was going to ask you, we may come back to continue with this. So at such of the points though, what would be the areas the defense attorney could have made a mistake? What could be the areas the defense attorney could be successful?
Sure.
All right. Okay, my dear friends, let's take a short moment out. We come back to continue because I laid down several questions, big ones and important ones. And these are important, so important to you, because the whole purpose for talking about Zhou LiBo's case was that we want to make it as an example for you to learn, number one, about laws, number two, how you want to protect yourself once you unfortunately get involved in a situation similar. So stay with us. Hello, dear friends, the lovely audiences. Today with me is my good friend, Detective Tom Yu. He is a defense attorney, a successful defense attorney for hundreds of cases. We are sharing his thoughts, we're using his experiences, being a detective, being an attorney from all angles to talk about the Zhou LiBo case, using that as an example to show the U.S. laws, to first understand the U.S. laws. By doing so, we want to focus on the two areas. One area is that we want to make a better understanding about our laws. The area number two is that if you are unfortunately involved in a situation like this, what is the best way to do to get your best attorney? So what is best attorney? All right, that's the question. So, and I have Tom Yu here to share with you. So, like I said, in those areas, in which area attorneys could make a mistake, or in which areas attorney could really show something different, please?
I can tell you, Jack, that I was a detective for a very long time with the Sheriff's Department. I handled major cases, major narcotics, shooting, murders, stabbings, robbery, home invasion robbery, and I've gone to trial dozens of times, and I could tell you that I know when I see a good attorney or when I see a bad attorney. I could tell you also that most of the time, the good attorneys don't advertise. Good attorneys don't have big billboards.
They don't have to, right?
They don't have to. and a very a funny.
You know, that's why I don't advertise myself.
Right, and I don't either.
Oh, thank you.
And I have lost a couple cases as a detective. They're all to attorneys who just know their stuff, go to court, represent their client, they go home. They don't have billboards. They don't advertise on the Chinese TV. They don't have newspaper ads. They're good trial lawyers. To answer your question, this case, I think several of the issues here I mentioned, a lot of attorneys doesn't understand what actually happens in police work. They're not police officers. So when they only know this side of the game and they don't understand the ground game, it's very difficult for an attorney to, it's not their fault. They just don't understand this game. They don't understand how police work is done.
Understood.
Practically,
Yes.
it's done.
Exactly.
So
and in your case, if you had not been a detective, you might not understand what the cops part is, right?
Absolutely.
Yeah, sure.
And a lot of attorneys do not know that, hey, when a cop stops a car, there's a lot of things that go on. First, the cop doesn't want to get shot and killed. We call that officer safety. You know, aside from the court proceeding, the cop is not thinking about court. The cop is thinking, I don't know this car. I don't know who's in the car. I need to get the person out of the car to see if there's a gun in there, to see if I'm going to be safe. That's the number one concern, right? Now, to get back to your question, when this thing goes to court, and oftentimes, and unfortunately, it's never happened to me yet. I've never been fired by a client. Now, I've seen
Good
this.
for you.
Well, I've seen this a lot as a detective,
right?
right?
Good,
Where
good,
criminal
good.
defendants fire their attorneys because maybe they don't get along. Maybe there's a language barrier. Maybe the attorney's too expensive. Maybe the attorney's not doing the job up to the client's standard. And oftentimes, Jack, it's communication. A lot of attorneys do not communicate with their client to a level that the client can understand. Now, in this case, I think what I would have done, and I think a lot of, and certainly the last counsel has done for Mr. Zhou, was file a motion to suppress. And really,
motion
to suppress the evidence. Because that's the first thing I would have done out of the gate. I wouldn't even wait for the preliminary hearing. The trial one, I wouldn't even wait for that. I would get out the gate and say, show me why prosecution, because you have the burden, show me why and how you searched the trunk of my client's car.
I see.
Show me why and how. Because if you do not make that showing, I don't care if you find a dead body in the trunk. It's not coming in.
Oh, speaking of that, I was going to exactly ask you, right? So, okay, go ahead. And I will ask, I do have a body question to ask you.
Okay,
right?
I love body questions.
Okay, body question. So now focus on the, a request of suppression of evidence, right? So for that, obviously in this case, the first attorney did not file that.
Well,
or otherwise the overturn will not be delayed for that long.
Right, and this may be a strategy difference, okay? In California, I don't know about New York law. In California, you can only file a motion to suppress one time. So a lot of times, defense attorneys don't file that until after the preliminary hearing because they want to know what the officer knows. Well, here's the problem. You're gambling. I'm not a gambler. I like to file the motion first because if I can get rid of the evidence, why go to a preliminary hearing?
All right, good.
You're prolonging the danger of your case.
That will even take care of the preliminary hearing.
Yes.
Because there's no evidence at all, right?
Evidence. Now, every case is different, Jack, okay? Every case has its own set of unique facts that would dictate its case. I've had cases where, as a detective and as a defense attorney, where I'm like, well, the evidence is very strong. I'm not going to waste this one shot of motion to suppress. I'm going to wait till what I see in preliminary hearing and then do it later. That's fine. Nothing wrong with that. But I think in this case, the evidence is so strong that the police officer here, the arresting officer, didn't have enough evidence So why wait?
All right. I know what you're talking about. Without knowing the professional terms or understandings, by logic, you want to make sure that your first shot kicks the point, the very point, saying, where is the evidence and how did you find it, right?
I'm going to give you, yes, absolutely. I'm going to give you a very short example. My office just got retained on a trial case. The attorney that had the case for 1 year. Big time advertiser. Billboards, advertisement everywhere. TV, newspaper. Had the case for 1 year. 0 motions. He did 0. Nothing was done on the case. I came in about 4 weeks ago. I filed 2 motions, and I think I can get this case kicked from jury trial. If not, I'm going to trial next month. But I've done in this short amount of time what another attorney didn't do for 1 year.
That's the difference here. That's the difference, yes. That's the difference here. That's why I told my audience it's quite necessary, rather necessary, to find out what is a good attorney or bad attorney. And money is an issue. Money is not the only issue, because sometimes, even though, in this case, LiBo's spent about $200,000. No, the first down payment, $200,000 for the first attorney. And it was given, the message was given was that if we did go to trial, which in that case, if he did not change the mind, they did have to go to trial. Another $500,000. That's $700,000 altogether for a case. Of course, thank God the guy changed his mind to fire the attorney and to get another one. This very one got him off for $20,000.
It's about a $20,000 case.
For $20,000.
Yeah.
Right. So that's the difference. A good attorney or bad attorney whatsoever.
Absolutely.
Okay, now explain a little more. Spend some more time on the suppression of evidence, please.
So
that's so important to us.
The suppression of evidence, basically, the Constitution says that the end does not justify the means.
What?
The end does not justify the means. So you do not take the end result and say, well, even though you didn't have a warrant, and even though your arrest was bad, you don't justify the arrest by what you find at the end. Because if you do that, then you're perverting our Constitution. I took an oath 3 times. When I joined the Marine Corps, when I became a policeman, and also when I became an attorney. And all 3 oaths.
You were a Marine Corps yourself.
Yes.
Oh, you're everything.
Well, all 3 times,
what a wonderful life, yeah.
Where all 3 times, I swore that I would defend the Constitution of the United States, okay? And the Constitution says that our rights are very important. So it doesn't matter what you find at the end. If the way you got there is improper, the law is going to punish what you find at the end and kick it out. That's how we preserve our rights.
So what if I found a dead body there?
It's a very good question.
Tied up and dead.
I handled a murder case right before I retired.
All right, yeah. So can we ignore the dead body? Well,
let me give you this example, and I think it will come to light. I handled a murder case out of Monterey Park, where a body was stuffed inside a trunk on a very busy street in Monterey Park, right a couple cities down. The body was in there for about 6 weeks. Okay.
6 weeks?
6 weeks inside a trunk, a Lexus. And the smell was so bad, the citizen thought there was trash inside. So the citizen called the police and say, hey, can you tow this car away because it's been there? And there's parking citations on it, okay? So the police says, okay, fine. They come in, they open the trunk because there's nobody there. And they, oh my God, they found a body, a dead guy, okay? Now, it took 6 weeks to do that. Well, why? Because body will decompose and there's a smell to it. You never forget that. There's a smell to a dead body. In the comedian's case, Mr. Zhou's case, let's say there's a body in the trunk. The Fourth Amendment says,
yeah, that's exactly what I think of.
Okay.
If there was a body in the trunk.
Okay. So let's say there's a body, cocaine, and a gun.
Okay.
Let's go with the body. Okay. The law says, well, generally speaking, as a general matter, if you don't have a warrant, everything in that trunk is not coming in.
All right.
Generally speaking, unless the prosecution can come up with an exception. Well, there's an exception under the Fourth Amendment called the inevitable discovery rule. Inevitable discovery means at some point,
Inevitable discovery.
at some point, you're going to discover this body.
Yeah, when the smell comes out, and
At
it's
some
like,
point
"Hey, I
you
got to
want
see what's inside, right?
But the prosecution have to make that showing and argue to the court and say, hey, Your Honor, this is a dead body. It's not a gun or cocaine that's going to rot and draw attention from the citizen. This is a body, a human being. It's going to smell. So at some point, someone's going to call the police and say, hey, there's a body in the trunk, like the case of murder.
But
that I
they
handled.
first have to assume there is a body there before they can discover the body, right?
Well, the exception to the Fourth Amendment says that if the prosecution can show by a preponderance of evidence, which means more likely than not, 51%, that at some point in time, someone would have discovered the body, then the body would have come in, even though the cop made a mistake. But as to the gun and cocaine, no way. It's not going to come in.
No. Okay, now, we did, let's take a moment out. We come back to continue. Looks at this is very interesting area.
Yeah.
We want to stick in to find out more that we can learn from. My dear audience, today with my friend Tom Yu, we're learning a lot. And well, you know, we're law-abiding people. We want to understand laws. And in the meantime, constitution by constitution, we're protected by the laws, not attacked by laws. So that is the case, right? Using Zhou LiBo's case, though, we try to get a better understanding about what the laws are. And in our day-to-day life, though, we all want to get ourselves prepared in case if you are wrongly accused of something, well, you need a defense attorney, right? Defense attorney, good or bad or whatever. So how to define? So what's the difference? Okay, you will know. Okay, stay with us. We'll be right back. Hello, my dear friend, my lovely audience. Welcome back to the discussion about the Zhou LiBo's case, which is used here, not talking about the case, which is used here for an example to dissect, to see if we can learn from it for the purpose of understanding our laws, for the purpose of understanding what is a better attorney, what is the good attorney, what is the best attorney, and what is the defense attorney, and what they can do for good, what they can do for mistake, something like that. Okay, now, back to the trunk, right?
Sure.
We'll continue. With me is my friend Tom Yu. He is the detective, former detective for LASD. By that I mean he knows the whole thing of law enforcement, right? Okay, and then he's the attorney of law. His defense attorney, he knows the course in court, in and out. And thirdly, he himself handles hundreds of cases. And before that, he was a Marine Corps. So you were everything. So what a wonderful life, young man, I would say. Okay, now, back to the trunk, okay? Now, we assume different situations, right? In situation A, the cop opened the trunk without the consent, found out a gun loaded and a bag of cocaine.
Sure.
Right, okay. And situation number 2, which is B, the cop opens the trunk without the consent, right? Found out a gun loaded, bag of cocaine and a dead body, right? And the situation number 3, which is C, the trunk was opened the same way and found out nothing but a dead body, right? And 4, which is D, the trunk was opened the same way and found nothing. how would you interpret the 4 A, B, C, D situation?
Well,
Okay, once again, I want to make it clear to you. Number 1, with the guns in the bag, right? Number 2, with the guns and with the body. Number 3, with the gun and the body and the cocaine together. Number 4, none, right?
well, I mean, obviously, if the cop didn't find anything in the trunk, I mean, there's no discussion there. There's no constitutional injury. So
But you opened my trunk after against my consent.
that's fine.
Against
And-
my
and-
will.
And great. But as far as the Fourth Amendment's concerned, because there's no fruits yielding from the poison, there's no violation as far as that scope of the matter. Now, you can sue them for a civil rights violation.
Fruit yielding from a poison tree.
Right. If there's nothing to be found.
Good,
But if
good
there's
philosophy.
cocaine and the gun, we discussed that earlier. Obviously, those two items are not coming in unless there's an exception. And from what I could see, there's no exception. Now, the body, I discussed earlier briefly about the inevitable discovery rule, where if the prosecution always have the burden, okay? If the prosecution can show that at some point in time, a body, it can decompose, and at some point citizens would have came over and smelled it, then more likely than not, the body will come in. I'll give you an example, okay? Let's say I'm out in San Bernardino County in the high deserts. I drive and I'm off on a road where nobody goes. Cop pulls me over. Same scenario. I have a gun, cocaine, and a body. Can you really demonstrate that in someone time that a citizen would discover the body? That's pretty hard to show, right? That someone's gonna just smell that in the middle of the desert. Versus my case that I mentioned to you, you're on Garvey and Garfield in the middle of the busiest intersection in San Gabriel Valley. Do you think someone will pay attention over there or versus the desert?
Yeah,
It's
of course,
fact
yeah.
intensive. Where is the
Yeah.
car? How close is it to the community?
I see.
Are there people walking by? Right. What's the foot
In
traffic
other words,
like?
sooner or later, people will discover that.
Right, and the Fourth Amendment says, well, if somebody's going to discover it, with or without the cop's bad conduct, this fruit,
Yeah, people say something wrong.
yeah. But the cocaine, the gun,
Or the family member would look for the person.
well,
Okay.
and again, it all depends on what the facts of that case is. But I'm speaking very narrowly to what the inevitable discovery rule says.
In other words, are you saying in A, B, C, D, none of the situations the cops by constitution can open the trunk without consent? Am I right?
Yes and no. I mean, the police officer can open up a trunk in many situations if they're inventorying the car. If the person's on probation.
Except inventory. Except
well,
inventory.
If you're on probation, if you have search conditions, I can.
The guy no probation, all right?
Okay. Well, you said only. So when you
No,
say
I
only
know.
to lawyers,
Okay.
we
Given,
get scared.
Given the situation that
Okay.
Mr. Zhou LiBo's was not on probation,
Right.
right? And then there is A, B, C, D, all the situation, all right? In none of the situations will the cop forcefully open the trunk, except he can inventory the car.
Sure. From that situation,
Mm-hmm.
given what I saw, yes.
Yes, okay, good. Another question, right? What if the trunk is opened and find a body there and the human being was still alive? Thank God the trunk was opened in time. If it was 5 minutes late, the person would have died.
Right.
So does that make a point? Does that help the cop?
Well, first
Harlan.
off, no, because so if the cops stop a kidnapping from happening, the defendant here doesn't. The defendant here, if the defendant kidnapped this person, are you asking me if the Fourth Amendment is going to exclude the evidence?
I'm only talking about a cop stopping Mr. Zhou for making a cell phone call.
Right.
Right? After checking when there's no alcohol, no drug, whatever, so on and so forth, and then a ticket, okay, go, like that. At that point, decided to open the trunk
Yeah.
without consent. And sure enough, he found a human being there,
Sure.
tied up, mouth stuck,
Yeah.
right, and still alive, and was opened just in time to save a life. So
Great, nothing
So,
happens.
great
I mean,
discovery.
nothing happens because that's
So-
the human being's not evidence. The human being is not evidence. The human being is a person. A person is not a piece of evidence. So the Fourth Amendment only excludes property.
So
things that
can the prosecution prosecute the driver
Yes.
for having somebody tied up there,
Absolutely.
endanger the life,
Well, there's no reasonable expectation.
or
of-
somebody else who did it whatsoever? They need to find out.
Right.
So
There's no reasonable expectation of privacy when you're committing a crime and concealing a human body. So in other words, you don't have a reasonable expectation of privacy in the trunk, where that trunk is actually an ongoing crime. So the cop can absolutely, if the cop believed or not believe, so happen that there's a human being in the trunk, it's great. He's going to get a medal.
okay, let's develop a little bit. All right. Suppose Mr. Zhou for sure had nothing to do with the human being in the trunk still alive. If somebody wants to use his trunk for human trafficking, for example,
Okay.
right, without his knowing. So is he still prosecutable?
I don't know. I mean, there's going to have to be more things to this scenario. For example, whose car was it? When did the person get
It is
in?
his car.
Well, you know, and like I said, the law presumes that, hey, if you're driving a car and there's a human being in the back, presumably he's making some noises. You cannot put your head in the sand and say willful ignorance. That's not a defense. It depends on what the human being says. Was it, you know, there has to be some more facts.
Similar like a motel owner, right? If somebody doing cocaine in your room, though, motel owner is responsible. Am I right?
Not
No?
criminally. No.
Not criminally.
In a motel situation, it's very tricky in motel situations because then the person doing the drugs has a reasonable expectation of privacy in that room. So the police actually need a warrant to get in there, unless an exception applies.
I see. All right, we are over time, but we are happy about it. Finally, we got a chance to learn something which we never know. And I don't know, thank God, a human brain can hold that much of information. Yeah. And he is much younger than I am. My dear friend, Tom Yu, we all want to thank him for being a detective, active in Southern California for quite some years. And lots of cases were handled by him, and lots of puzzles were resolved in his hand. And also, he is an attorney, defense attorney, handling lots of cases successfully. And good record is that he's never been fired by a client, right? That's a good part. So thank you for that. So if necessary, sometimes may I call you again for some education?
Absolutely, John.
All right, please.
Anytime.
All right, good.
Thank
We
you.
heard that promise, right? Okay, my dear friends, thank you for watching.